You should be aware that trying to understand the meaning of law without first and foremost discussing theories of law is just as trying to evacuate a river using a cup. How possible do you think that could be? Theories of law is an area of law that no student of law should joke with, because law, as asserted by Thomas Arnold, has no universal definitions. Over the years, various authors, various jurists in the field of law has made an attempt to define what law is all about. But amidst all the definitions, none has been universally accepted as the meaning of law. So theory of law presents us law students, future lawyers, lawyers in equities, and barristers, and the present day judges, what law and its meanings basically entails. Theories of law will give you ground as to the understanding of the overall meaning of law. And in today's video, we are going to consider the positive theory of law. Let us see what the theory says, as well as the various relevant authorities in that field. However, don't forget, we have made a video on introduction to legal method. We also made a video that discussed the meaning of law. And today, we are focusing on the positive school of law. This our lecture video on positive school of law will be categorized under 4 phases, because positive school of law is a big sphere of law and it's not something we can actually do justice with within a 15 minutes or 12 minutes or thereabout. So we are going to phase it. The first phase, which we are going to discuss today, is the overall meaning or the claim of the positive law. Then on the second phase, we are going to consider the types of positive law, because positive school of law is the only school of law or theories of law that presents two divergent views under one phase. Although two of them still speak to one thing, but they have two visions to achieve or missions they intend to achieve. We have the John Austin command theory or the imperative theory. We then have also Hergensen theory, which dealt with pure theory, or what we call in constitutional law as the theory of ground norm. We are going to consider that two of them. So second phase is going to be John Austin command theory. Then third phase, we are going to consider Hergensen pure theory. And then we get to the fourth stage where we are going to consider the criticisms and the advantage. If this is your first time you are joining this channel, subscribe to King's Advocates Network, because every single week, particularly on Saturday, we post a video here that has to do with law. Either it is explaining or telling you the law, or it is showing you where to find the law, or legal updates that has to do with news that concerns law. So I encourage you to subscribe and turn the notification so that every day when we post a video, it will show on your screen and you'll see how that video could help you to achieve your excellence in your academic job. Law. We start with what is positive school of law in its ordinary and simplest meaning. Positive law, reduced to its simplest terms, simply refer to laws that are created and enforced by human authority, such as legislature, courts, or government. It contrasts with natural law, which is derived from moral principle or divine authority. So you could see positive law theory or legal positivism as a school of thought in law, which focuses on the idea that law is a creation of human beings. According to this theory, laws are rules established by legitimate authority within a society, and these rules must be followed by members of the society. I want you to get this and get it clearly. Whenever you are discussing positive law, simply have it in mind that positive law is simply a theory of law that posits that law is that which is created by human being. Positive law basically contrasts the idea of natural theory of law, which says that law is that which is written on our minds. Law is that which is entangled with emotions, with a notion of morality and non-morality. The idea of positive law is that law is that which is created by human being. Law is that which is declared to be law, and any other thing that is not declared to be law is not law at all. But natural law says, I made a video on natural law and I will not even preempt that video. You can go to my legal method and legal system playlist and check a video that has to do with natural law. Although I will try to contrast as I'm speaking on this positive law. So natural law is of the view that law is not that which is just written down. That law goes beyond what we see as law. But positive idea of law is that here, law is nothing but that which is contained under statute, which is declared to be law, and any other thing that is not declared to be law is not law. It could be a moral obligation but should not be regarded as law. That is what the idea of positive school of law is all about. See positive law as something that says that Anything that is not written down is not law. Anything that is not humanly made is not law. That does not just end with it. Now, let us see the characteristics feature of positive law. What you could actually say. Remember, we are considering the overview, and this is necessary because in our next lecture video, which has to do with John Austin's perspective, you are going to see that when we go detail, you will see that this over concept is very necessary for your understanding. And it's not something you can just approach on your examination and be like, positive law is that which posits that law is that which is made by human, and law is that which is clearly. It doesn't end with that. A clear appreciation will be rewarded by your lecturer. Now, characteristics feature of positive law is that first, it is man-made. The whole idea of positive law is that law is that which is made by human. Law is that which is made by human. And of course, you know that the idea of positive law has actually gained ground in our typical contemporary society. I don't want to go with that because when we shall discuss this and reach to that last phase of criticism and advantages of positive law, that is when you are going to see what I'm telling you. Positive law has actually gained ground because whatever we're operating today is heavily rooted on positive law. For instance, in criminal law, according to section 36 sub 12, no person can be punished except that offense is clearly stated. And section 2 of the criminal code defined everything that amounts to be an offense under criminal law. If you also go to the section 36 sub 8, you will see that no person can be punished except that punishment for that particular crime has expressly been stated. You see the idea of positive law. You see how it comes into play here. But positive law support the idea of the law as it is, lex lata, as opposed to the law as it ought to be, the leg ferenda. Natural law support the idea as the leg ferenda, the law as it ought to be. Yes, you ought not to kill. But the idea of positive law, thou shalt not kill, and if you kill, this happens. It's not about question of you ought not to, but it is written. That is what positive law entails. The second characteristic feature to note about positive law is that positive law endorses the idea of sovereign authority. I said that in the beginning of this video that positive law support the idea that law is that which is written, and it doesn't just end with that. Your father cannot just wake up and make a law that will be binding in the entire Federal Republic of Nigeria. Your father cannot just come and make a law that will be binding on the entire South Africa. Your father has the right to make a law that will be binding on your family, yes, duly supported. But your father is limited to make a law that will govern an entire community. That is what the positive law is saying, that for you to actually say that this is law, you must check the authority where the law is driving its precedent from. You must check the validity of a particular law by checking where the law is proceeding. In other words, I cannot wake up and say, I declare that nobody should come out every Tuesday. As who I am, as a king's advocate, I have no right. But the legislature sitting in a parliamentary session can make a law to that effect that for the purpose of this, for the purpose of that, nobody should come out on Tuesday, and it becomes law. The idea of positive support that because it is proceeding from the right authority. So know it today that when you are discussing positive law, the theory support the idea that for law to be valid, it must proceed from the right authority, and any other thing contrary to that will render that law null and void. That is what the idea of positive law is. So first one is that it supports the idea that it is a man-made. Second one is that the law must proceed from sovereign authority. And then the third one is that positive law separates law from morality. The third argument or the characteristic feature of positive law is that it tends to separate law from morality. When you are discussing natural law is nothing but an embodiment of morality. Natural law is to the effect that any law which is not good should not be obeyed, lest injustice and unlawful acts. But positive law support the idea that whether the law is good, is not good, is just, is not just, provided that the law is proceeding from the right authority, that law is good and it should be obeyed, regardless of whether the law is good or not good. So assuming now the parliamentarians or the legislature wake up tomorrow and decide to make a law that will abolish the right to life. Of course, I don't think this is possible anyway, because the right to life is not derogatable. The right to life is not negotiable, and the right to life is not something anybody can tamper with, constitutionally speaking. But I'm giving you for an instance, if the legislature make a law to the effect that right to life should be taken under some certain circumstances, that becomes law. Even though the natural law support the idea that nobody should be killed regardless of whatever somebody has done, because the positive believe that law proceeds from the right authority, it should be obeyed. If the legislature wake up tomorrow and make a law that nobody should go out, nobody should move, nobody should do this, nobody should do that, provided it's proceeding from the right authority, the law should be obeyed. But natural law says that for law to be obeyed, it must speak to reason. Lex injusta non lex est. The fourth characteristic feature of positive law is that law is binding and enforceable. Unlike natural law, I use natural law in tandem with this positive law simply because two of them is opposed to each other. They present a contrasting view. Not that they are the only theory of law we have, but two of them ought to always contrast each other. So the idea of positive law is that law is enforceable and is backed by sanction. Any law that is not enforceable and is not backed by sanction should be disregarded. Any law that is not backed by sanction should be disobeyed. And this is where also we are going to discuss when we shall get to the criticism. I'm going to tell you there are some laws that are not backed by sanction, but they are still obtainable in a society. Do you say that that law is not law at all because it's not backed by sanction? The argument there doesn't hold water, but this is what positive laws say. Positive laws say that law is that which comes with sanction. If the sovereign has made a law, the law ought to be obeyed. And if any disobedience to it will come with sanction. But natural law doesn't go with that. Natural law support the idea of that even though you ought not to. Not that you are mandated not to, but you ought not to. The fifth characteristic feature of positive law is that law is dynamic. Positive law is the only theory of law also in line with realism theory. They are the only school of law that tries to grow with the growth of the society. Positive law is very dynamic, that it changes over time. It was not law that was made during the era of Queens of England and all those area of monarch that is still obtainable in our society today. And in a typical federalism like ours, sovereignty is obtained on the constitution and not on the monarch. So based on our contemporary society today, we see that positive law has grown with the growth of the people. In the ancient days, whatever the kings deems as law becomes law. That was the idea of John Austin. When we shall consider that on next week Saturday, I'm going to tell you what John Austin said that law is. And of course, you know that you cannot discuss this positive law without calling people like John Austin, without calling people like Jeremy Bentham, without calling people like Hans Kelsen. These are the people you are going to mention to your lecture to actually tell them that you really read positive law. They are the people that advance this theory. So as I was saying, positive law is dynamic in the sense that it grows with the growth of the people. When the idea of positive law was developed, John Austin linked the sovereignty to positive law to a monarch. That is a king or a queen. Whatever a king makes becomes law. The will or the wishes of a king or a queen becomes law. But in our contemporary society today and in our modern society, sovereignty is no longer obtained on the king, especially those practicing federalism. Sovereignty is obtained on the constitution. The constitution, by virtue of section 1.1, is supreme. And also by virtue of section 1 sub 3, any other law that is inconsistent with the constitution become null and void to the extent of that inconsistency. You see that the sovereignty has moved from the king or Mr. President or Mr. Governor now to the constitution. So the king or Mr. President or the governor is no longer the authority, is no longer the sovereign. But who is the sovereign now is the constitution. In other words, Mr. President can say that, please shoot everybody here. If the soldiers drive to do that, they can maintain an action against the soldier because the soldier has breached the law, even though it was the command of Mr. President. But Mr. President's command in this case cannot override the constitution, which has established by virtue of section 33 that every person has the right to life. And such right can only be taken in preservation of the societal peace or in the execution of court order. So you see how the positive law has grown with the growth of the people. Positive law is very dynamic. It's very unlike other theory of law that is very static in nature, that remains what it is today, even in next 100 years to come. I believe this is a clear overview of positive law. And in my next video next week, we are going to proceed to types of positive school of law, or types of legal positivism, where I'm going to teach you everything that has to do with imperative theory, that is command theory. Then it is on that note I'm going to tell you the legal philosophers that have advanced the theory of positive school of law. From there we proceed to the criticism and every other thing, and how you are going to approach it on your examination to actually make your mark. If you want to watch my video on the natural law theory, click the link above. We have also made a video that has to do with overall meaning of law, introduction to legal method. Go to our playlist and check out those videos, because all of them is going to help you. Please kindly subscribe to King's Advocate, and I will see you next week. Remember to like this video. Thank you and remain blessed.